Hello friends, how are you? I hope you all must be very good. Okay, this is Salat Hassan, your faculty, and I welcome you again to my course Fundamentals of Contract. Here we are meeting again with our second module, but before we get started, let us have a quick recap of the previous module. What we did in the last module. We did nothing special as such. Just we discussed in brief about brief history of the Indian Contract Act, and we also got to know in brief about the term contract itself. We've seen about two terms, agreement and contract. And guys, actually the term agreement seems to be so formal, but it was very clear in the last module that there was nothing formal as such with the term agreement, though it sounds to be formal, but what actually formal is, that is your contract. What is formal? That is your contract, and it's a legal term actually, and not the agreement. We have also seen, guys, that the term contract is not as such very complicated. It is as simple as more often you go to a parking area, you book a slot, you park your car, and you are given a stamped paper, you pay for it. That's a contract. Also, if you drop your coat at a laundry for dry cleaning and you're given a receipt for that, that is also a contract. So it's very simple. In fact, our life is dominated with the day-to-day contracts only. And we also, in the previous module, studied 3 sections. B, E, and H. What are the clauses of which section? Can you tell me? Yes, this is section 2. We have seen, we are very clear. I'm sure, guys, we all are very clear till now about these 3 clauses of section 2. Section B, clause 2, which talks about the promise. Again, I'm trying to write very beautiful. And this is E, this is what? Agreement. And also, not also, this is the main thing. And this is what? H, which deals with the term contract. But as these two, promise and agreement, were quite necessary, they were quite, collateral to the definition of the term contract. So we studied these two also. Don't worry, we won't go into details. We know this much, at least this much promise, agreement, and contract. We are very sure. I'm very sure we all are done with this at least. So now let us start our second module. And what is our second module? It's about the definition of the term fundamentals of the definition of the term contract. What is the definition? We already know 2H that an agreement enforceable by law is contract. So we know the definition. Now, do I really need to define the term contract again? Is the definition of any term that important? Yes, I would say yes, the definitions are very important. And why? Because the very first thing, this is the definition of a term only which expresses the essential nature of that particular term, what the term is actually about. And it is also the definition only which helps you, which enables you to trace the common understanding of that particular term. How? Guys, when you go through the different definitions, when you go through the different viewpoints and you analyze it all together, then finally it makes you reach at a common understanding of all the different viewpoints. So the concept is very clear. And the third thing and the obvious thing is that the definition of any term is a key to understanding to that particular term. So because of these reasons, yes, I would say that defining any term in the proper sense is very necessary. Now, at this point, I would like to quote one person, Abraham Lincoln. I hope we all are quite familiar with this name, Abraham Lincoln. What he said? Abraham Lincoln, he said, just give me 6 hours to chop down a tree, and I would like to spend first 4. Getting? He would like to spend first 4 on what? On sharpening his axe. He said, give me 6 hours. Guys, listen to me. Give me 6 hours to chop down a tree, and I would like to spend first 4 on sharpening my axe. Now, please don't go into the literal meaning of the term tree and axe. That's just symbolizing something. What he said that because he thought it so necessary, making the base of something is very necessary. Obviously, look, if you sharpen the axe properly, there are chances that your tree is easily chopped down even before those 2 hours. It even won't take those 2 hours. So obviously, if you define the term properly of your any term of your course, or whatever the term, the entire thing, the further modules, the next modules are going to be very smooth and easy. So obviously we are going to sharpen our axe as well. So let's start. In this module, we will be dealing with few important and selective definitions, and of course also with a few different kinds of contract along with their definition as well. And finally, we'll see section 2H. We'll just try to break it into parts and find out the ingredients from there only. Okay, let's start. Okay guys, here I have written few important and selective definitions. I have already written it for 2 reasons. Obviously, I didn't wanted my video to stretch unnecessary, and because the definitions are pretty long, and as you know, I write very beautiful and very fast, so it would have taken more time. And obviously the other reason is I wanted to quote the actual words of these definitions, so I have written it down. You can write it down if you wish. Guys, look, if you are a student and you are appearing for any exam, these definitions are very important from that point of view, because more often in your competitive exams, what happens, the examiner puts these definitions and they ask whose idea. So there you have to write whose definition is this. These few dictionaries are not that important, but yeah, obviously the few upper ones are, the name of few upper ones are very important. So let's begin. This first definition, Frederick Pollock, he was a legal scholar and historian as well. What he said about the term contract, just have a look. Every agreement and promise enforceable at law is a contract. What Frederick Pollock says? He says that every agreement and promise enforceable at law is a contract. Look, he used 2 terms, agreement and promise, though I feel that using 2 terms, agreement and promise, are not very relevant. This is what I feel, because agreement, when you define agreement, it's obviously what? It's a promise or a set of promise. Actually, it's a promise or set of promise forming consideration for each other. So the term agreement already includes within it the promise. So I don't think this is a little bit of stretching. So don't okay, just leave it. These 2 terms are not that very relevant. What is relevant is the term agreement, and the other important term is enforceable at law. So the 2 terms of this Frederick sir is very important, agreement and enforceable at law. Now let us come with the second definition. What it says, Salmon, everyone, all of us know, we have seen, he has given various definitions of law and command, many things, So Salmon, he says, a contract is agreement creating and defining obligation between 2 or more persons by which rights are acquired by one or more to acts of forbearance on part of others. So what he says, in his definition, I find he says a contract is agreement creating and defining obligation. So agreement, again you find a term agreement. This is of course important, and the other part is creating and defining obligation. What is this? Creating and defining obligation. This is what the enforceability is. What is enforceability by law? That is what a defining criteria. The enforceability is which brings your rights and obligations, which define your rights and obligation that can be brought to court. So these two terms you find in Salmond also. And the other thing he says that where the rights are acquired by one and forbearance on the part of other. Obviously, if you're getting a right, you are going to exercise against whom? Obviously, there is somebody, the other group against which I am going to exercise my right, and the other persons are excluded. They are forbidden from against that right. So a very comprehensive definition and a good one. And the next definition, third one, is William Anson. What he says, just have a look. A legally binding agreement, a very inclusive term, and I just like this. A legally binding agreement, this entire part up to here is summed up in these three terms. A legally binding agreement between two or more persons when rights are acquired by one or more to acts of forbearance on the parts of other. Only three terms are different, which defines the entire definition, and the rest of the thing is common, what he said, Salmond. So he also said a legally binding agreement. Then legally is the term which defines the enforceability, legally binding, and this is agreement. Again, these two terms are common, and the next part is obviously the right for one and the forbearance for other. Then just have a look at the fourth one. This is from a law. Guys, at times, the law dictionary's definitions are also very important. So Duhame's law dictionary defines the term contract as an agreement between persons which oblige each party to do or not to do a certain thing. What it says? It says an agreement. Again, this also, obviously, what you are able to see that the term agreement is common, because there cannot be a contract without an agreement. So obviously, when you are going or anybody else is going to define the term contract, they would start with the term agreement. That's a base. So an agreement between persons which oblige, and this term obliges again, which reflects enforceability. Each party to do or not to do certain thing. One more element, one more ingredient of the term contract is added here. To do or not to do a certain thing. What it says, to do means obviously it's a positive act, an overt act. You're going to do something. There's a contract for doing something. And the not to do a certain thing, this shows that a contract can also be for a negative act, means to stop you, to forbid you from doing something. What is a negative act or a forbearance? This we will see in the next modules with help of few examples, and then that is going to be very clear. Okay. Since we are dealing with definitions right now, so I'm not going in that much detail. Next definition is Justice Janosek of Alberta Court. Justice Janosek is a very renowned justice of his time, and the definition given by him, actually he's not given a definition but a very inclusive, he has tried to define the contract in a very comprehensive way and with many other ingredients. I have just taken a part of his judgment, and there are many more things which shows about the other ingredients of the contract as well. What he says, essence of contract is agreement. Obviously, I am telling from very beginning that the essence of contract is agreement. There can be no contract without an agreement. There is a chain we have already seen, because a contract is the part of the agreement. Now we have seen that syllogism, that diagram, Venn diagram, that this is an agreement and this is a contract. So there can be no contract if there is no agreement. So he says essence of contract is an agreement. And it is a legally recognized agreement. Again, he also talks about the enforceability. That is legally recognized. Legally recognized agreement between two or more persons giving rise to such obligation that may be enforced in the courts. Obviously, if it's a legally enforceable, then where it is going to be brought? Obviously, before the court. Court is to come in action and enforce the right of the party, and it says about two or more persons, agreement between two or more persons. Obviously, one more element, that it must be a bilateral. There can be no contract unilateral. You cannot contract with yourself. You need somebody who must accept your offer. So the next definition is here, step by step we are getting one more additional element of contract by the definition. Here we got about the act or positive or negative act. Here we come to see about bilateral contract. There must be two or more parties. And then we'll come at the next definition by French Civil Code 2009. It's a French Civil Code, and it says a contract is an agreement by which one or several persons bind themselves towards one or other to transfer, to do or not to do something. This is what the same thing what we have studied in the above definition. It also says it's an agreement. A contract is an agreement, obviously, very true, by which one or several persons, again it says about one or several, not a unilateral. It is about bilateral. One or several persons bind themselves. Binding means what? There is not necessary that every definition use the term enforceability. Binding is as good as enforceability. Themselves towards one or several others, and to do or not to do. Obviously, it can be a positive or a negative act. Then we have the next definition, Cubic Civil Code. What this Cubic Civil Code says? A contract is an agreement of will. What it says? A contract is an agreement of will by which one or several persons obligate themselves to one or several persons to perform a prestation. Now, in this definition also, we find two new terms. What is that? One is will. One is will, and the other one is prestation. Guys, these two terms seems to be different. Actually, it's a different vocab used for the same terms which we have used in earlier definition. Will is what? Will is nothing, not the testaments. This is will is something, your free will. That is, it should be made voluntary. Obviously, the contract entered into due to any pressure, any undue influence, coercion, those are not valid. So it talks about a contract which is entered by will, out of free will, voluntary. So this is nothing but voluntary. And the second term is prestation. What is that prestation? Prestation is also nothing new, just it's to do or not to do something. Again, this term, to do or not to do something, even if you find in dictionary, prestation is the same thing. It can be an either positive act or a negative act. So nothing new, just the terms or different vocab was used by Cubic Civil Code. And the last one, Webster, a very cute and simple definition. A binding agreement between two or more persons. This is what the enforceability, an agreement enforceable by law. Don't you think this Webster has defined a binding agreement between two or more persons? This is what our section 2H of Indian contract has defined it. A very simple definition. Any contract enforceable by, any agreement enforceable by law is a contract. So the same thing is here, a binding agreement between two or more persons. Okay, this was all about the 8 definitions we have seen. Now, tell me one thing. After getting through the entire definition, what can we conclude? What is the thing we can conclude? Obviously, we can see that there are two terms, two universally acknowledged terms while we are defining the term contract. Those two terms are agreement. Number one, agreement, and the second one is enforceability. Agreement. Number one is your agreement, and number two is your enforceability. That is your binding nature, enforceability. So, able to be enforced. So two terms are universally acknowledged. You take the definition from anywhere, you take the definition from anywhere in the world, you would find that no definition is without these two terms. Maybe the different shades are given, the different terms are used, but the sense will be the same, agreement and enforceability. Without these two terms, the definition cannot be complete. So, we have seen these few definitions. Now we will see different types of contracts and the definition as well.